tell you not to over a damn case of beer and a large pack of candy. Mr. Lestrade, they know you at that Walgreens. Every single time you go back to that Walgreens, you have about every single eye in the sky looking at you every 15 ways from Sunday, watching your every move.
Yes, sir.
Non-driving affidavit and all that.
That's why I
Just go over there and sign your bond.
I told him that he can't drive.
Yeah, I know.
We're nearly 120 miles an hour weaving in and out of traffic.
No, I got you.
I was getting back from work, like I had to get half a day. How much did it go back?
My only condition,
Could there be like a curfew or something, or like anything like that? Cause I have to.
nearly 120 miles an hour in and out of traffic.
I was one.
I'll talk to you in a second.
Sir, you were charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On January 5th, 2025, the officer was conducting surveillance as part of a traffic crimes task force of motor vehicles racing westbound on Grand Parkway, and the officer observed the defendant's vehicle traveling in lane 2 and another vehicle in lane 1. The motor vehicle slowed down to approximately 30 miles per hour before launching at the same time in a competitive manner, accelerating to well over 110 to 125 miles per hour in an attempt to outpace each other. The motor vehicles raced 3 times, then pulled into a Buc-ee's. The officer observed the defendant, but was unable to locate the other motor vehicle involved in the race.
So then it says also he picked up a felony evading. He was on bond for a felony evading and now he's picked up this case, a racing?
It looks like that's the case, Your Honor. He was on bond for the evading.
I'm taking away your privilege to drive. You are not allowed to drive, Mr. Lee. Do you understand? You will be signing an affidavit with me today promising me you're not going to drive. I don't give a rat's behind what is going on in your life. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. This is an affidavit that you're going to promise me that you're not going to drive. Do you understand? There's a burning building with 50 kids in it. I don't care. Do not drive. You are Joaquin Hernandez.
Sir.
Mr. Hernandez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 12th, 2025, the officer was dispatched to 7000 Gulf Freeway, and another officer had advised that the defendant would sleep in the driver's seat of the vehicle. The vehicle was on and running, and the officer observed a container of beer in plain view in the center cup holder. The officer made contact with the
Drinking while driving?
Yes, Judge. And the officer observed a strong odor of an alcoholic beverage, watery bloodshot eyes, slurred speech, and the defendant admitted to consuming beer, but did not state the amount. The officer observed a 12-ounce Michelob Ultra cold to the touch and a plastic bag labeled Margarita to go with a straw sticking out of it, mostly consumed, and an open pack of beer in the back seat. The standard field sobriety tests were performed, HGN 6 out of 6. Walk and turn and one leg stand were not performed due to the defendant claiming he had one bad leg. The defendant was read the DIC and declined to provide a sample, and a blood search warrant was signed and executed.
Mr. Hernandez, I'm going to find that there's probable cause to go forward with your case. Can you see if he has any prior DWIs, please?
Yes, Judge. I see no prior DWIs.
I would venture a guess that it's damn elementary that you're not supposed to have alcohol in the car. I am now taking away your privilege to drive. You will be signing an affidavit with me today promising me you're not going to drive, and I don't give a rat's behind what is going on in your life. If I find that you drive, and I don't care if there's a burning building and you have to save 50 children, I can have a contempt hearing. And every time you drive, you can be facing up to 6 months in jail and a $500 fine. Do you understand? Do not drive for any reason. You are Samuel Escobedo. Sir, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On January 26, 2025, at approximately 12:31 a.m., the officer observed the vehicle on East Sam Houston Parkway turn southbound in front of the officer, making a wide right turn and entering his lane of travel, forcing him to slow to avoid a potential collision. The officer observed the vehicle swaying within its lane and within the vicinity of another motorist. The vehicle accelerated to a high rate of speed of 61 miles per hour in a 45-mile-per-hour zone, and a traffic stop was then initiated. The officer made contact with the defendant and observed glossy eyes, slurred speech, and odor of an alcoholic beverage. The defendant stated he was coming from a party where he had 2 shots and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 3 out of 8, one leg stand 2 out of 4. The DIC was read and the defendant refused to provide a breath specimen, and an inventory search was conducted and the officer found 2 Modelo's cold to the touch and mostly empty and 1 pint of vodka. The passenger advised the vodka was hers and the beers were the defendant's. Blood search warrant was signed and executed.
Drinking while driving?
Yes, Judge, cold to the touch.
Mr. Escobedo, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm now also ordering you not to drive at all. Do you understand?
Sir.
You will be signing an affidavit with me today promising you're not going to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months of jail and a $500 fine every time you get into a car and drive. I don't care what your excuse is. Do you understand?
Sir.
I would think that it's elementary that you're not to have alcohol in the car while you are driving. If I find that you pick up a new case, you become a danger to my city, you consume alcohol or you drive, I will revoke your bond, put you in jail, no more PR bonds for you. Do you understand?
Your Honor, for my client. My client is
Did you catch how serious that warning was? The judge didn't leave any room for misunderstanding. Breaking this promise wouldn't just violate a court order, it could create an entirely new legal problem. This is one of the strongest driving restrictions you'll hear in a courtroom.
to make sure that
You know, I mean, he's 19. There's alleged 2 cold beers he's drinking while he's driving. No. I want you to appreciate the absolute privilege it is to drive. It's not a right. You want a right, take your Dutch patas and you can do that. No. If after a while you can show me that he appreciates it proactively, right? And I get it, then we can talk. But until that point, I don't care what you're doing. I don't care if there's a burning building, you have to say 50 children. You drive. It's really not going to go well for you. Do you understand? Mr. Ellis, let me read something to you. This is why the magistrate did not give you a PR bond in this case. Defendant on a 3-year deferred for a state jail felony since 3/21/24 allegedly stole CBD disposables. In this case, the witness called to report a man dancing around and waving a firearm in the air at the 5900 Long Drive in Houston, Texas. Law enforcement officers arrived, saw defendant matching the description as sitting at a bus.
The final case brings another reminder that DUI charges are about more than alcohol. They're about preventing tragedy before it happens. Which courtroom moment stood out to you the most? Let us know in the comments, and don't forget to subscribe for more real courtroom breakdowns.
In America, a young person dies just because of that very thing right there. Law enforcement officers struggled with the defendant as he continued to reach for the firearm, finally got him cuffed after approximately 6 minutes, then recovered a loaded .45 pistol from his pocket. One law enforcement officer injured during the struggle, pushed against the wall of the bus stop, sustained minor abrasions. Could have been another assault of a peace officer, which is a 3rd-degree felony, 2 to 10 in the penitentiary right there.
Judge, I anticipate the TRES recommending civil court.
Oh. This is a second bond violation report.
And that's why it's
It's a
2
second
year.
bond violation. He has an open DWI in another county, and now he's consuming alcohol.
Judge, the first one was from 2019 and he didn't have court until they didn't realize or didn't come to anyone's attention until he got this one. Then the officer told him, you have something open in Tarrant County, you may want to contact them. That's when he contacted them and then he told them, yeah, come to court for that. So it kind of fell by the wayside. I don't know what happened.
Sit for something. You get about a list of documents this high from lawyers advertising to you that you have an open case. I have to imagine that he knew about the open DWI in Tarrant County. Now he picks up another DWI. Now we're on a second bond violation report.
He's on probation over there now, Judge, and he'd be on a 2-year probation here.
No, this is not a good deal, man. I think that we're setting him up.
I think once he does the TRAS, and if they recommend cerebral court, which they most likely will, I think he'll be getting the help that he needs. I mean, he's 25 years old. So he understands that he'll have to.
I think that I would prefer to do it first, you know?
What do you mean?
Do the TRAS first so we know exactly what, because I mean, I would require, because of the nature, I'm going to do a repeat offender DWI education class number 1. I had no idea that he has an open one. Now he's got 2 BVRs. I don't think I'm ready to do this today.
Okay.
Not only that, you're on your second bond violation. You're continuing to consume alcohol, and you have an open DWI in another county. It's unacceptable.
Well, that one's closed now, Judge. He's on probation.
I understand.
He's on probation.
But he's on probation. I mean, he's had it open. He's now on probation, and he's a week ago he's consuming alcohol still.
Right.
I let him go once. I can't do it again, man.
Judge,
I understand that you have to zealously advocate for your client, but it's time. No,
what he was telling me was, and he showed me the paperwork, that the day after the alleged violations, when he was reporting to his probation officer, he doesn't understand how he would have tested positive when they would have tested him the next day. In fact, he actually got tested recently for drug testing. So they're drug testing him there and for alcohol. So I'm just letting you know what.
I have a scram. He's still testing positive for alcohol. It's unacceptable what's going on with you, Mr. Martinez. No, you know, I'm not ready to take this deal now. And I think that it's.
Judge, my only concern is if he goes in, as you know, with this administration, he's not coming out.
Consequences, man. Actions have consequences, Mr. Martinez. You know that. You continue to do whatever you want to do. You continue to consume alcohol. You know, you continue to put other lives in danger. It's unacceptable. Sorry, Marcos.
I'm trying to.
I know you are, but there's 2 open DWIs. He's on a second bond violation. It's not fair that I don't hold him accountable like I do every single other person here. I can't curry favor just because he may be undocumented. It's not fair, you know?
I understand.
Yeah, I'm revoking your bond, dude. You're going to jail.
But if he's gonna be evaluated, and most likely he'll get treatment, which is what he needs. Putting him in custody, he's not gonna get the
No
treatment.
matter what we're doing, no matter what conditions I have bent over backwards not to put you in jail. You literally had another DWI open, did not put you in jail. You have 1 bond violation report. I did not put you in custody. Now you have a second. It's now time to pay. I can't let you go again because I need you to understand that we mean business and you're not getting it. Even that you're on probation, you have an open DWI here. You still consuming alcohol. I'm sorry, Marcos. You're going to jail. It goes with you. Okay.
Yeah, Your Honor, I agree with State insofar as this is a simple matter. Where we disagree is, I think a scientist was needed. I think someone who actually has the technical know-how of how this violation report came to be. The state did have that standard of clear and convincing to prove that my client violated this. So far, all we have is a piece of paper that is, at least for right now, is supposed to have been prepared by someone else who is not here to testify. There's no ability to cross-examine them on their expertise, on any notions of false positives, on any issues that a technical expert would actually know about the device. And without that, Your Honor, I think it's very clear that the state failed to prove their burden of proof that my client consumed alcohol. And I would ask that, Your Honor, again, not revoke the bond, keep it as is. My client's here. There hasn't been any warrants for his arrest issued since he's been coming to this court. And in the allegations itself of the underlying offense, there is no allegations of injuries or accident to persons. So again, just take into account that you need to take into consideration flight risk and safety of the community. Nothing that's been established here in this hearing or outside of this hearing should lead the court to believe that my client is a flight risk or a danger to the community. And with that, I'd ask that you not revoke the bond, Your Honor.
And Judge, these devices are used.
Say it again.
These devices are used all the time.
Well, their use all the time is
Just so-
irrelevant to needing an expert to testify on that.
Absolutely. I absolutely appreciate your tenacity. I have done everything in my power not to revoke his bond. He is on bond for a DWI in another county. He picked up a DWI here. He's had not one violation. On the first violation, I didn't take him in. He had a second violation. I didn't take him in. Now he has a third violation. It would be unreasonable for me not to. I told you that there was no tolerance in this case. You yet refuse to comply with bond conditions. I find by clear and convincing evidence that you refuse to comply with bond conditions, and I have bent over backwards not to put you into custody. But now we have a positive blow. We have someone who has testified to it, and I believe it. So I am now revoking your bond. He goes with you.
We have the positive THC or stuff.
He had a positive THC, right?
Yeah,
As well?
that we sent him earlier this week.
He also tested positive for
THC.
marijuana as well.
Well, Your Honor,
Yeah, this week.
that wasn't, are we still on the record then on that? Okay. Well, I would also want someone to come testify about that, Your Honor, but you know, that I'll make, I know, but I know you already made your ruling, but I was ready to testify on that because they don't have anything on chain of custody on the test itself on whether it tests cannabinoids, which Delta-8, hemp. There are a bunch of things that are THC related that could pop positive for THC that aren't THC.
Regardless, we admonish him not to put anything in his body that doesn't have any delta whatever. Regardless, it's number 3, goes with you. A DWI repeat offender education class, 3 victim impact panels, 20 Alcoholics Anonymous meetings. I say we like get that done pretty quick, you know, because he has a real recent violation. So let's do maybe 3 per week for the first now, starting up now, 3 a week.
You could do more. You could have done. Yeah. They have them there.
Well, no. I'm doing this in a specific way so that it lasts for a long time. I don't want you to do all of them at one time. I want to do 3 a week, and that's how we're going to do it because I want them to last for a long time. I don't want you to do them all in 1 or 2 weeks. No. Do you understand? We are going to craft a plan for you. I'm going to have you meet with clinicians. You're going to be evaluated to see how we go forward because, Mr. Manzano, I don't know you. I've never met you before. All I know is how you look on paper, and it just doesn't look good for a 20-year-old. So the idea is that we craft a plan so you don't kill someone out there and end up with a 40-year sentence because that happened not 3 days ago. Do you understand?
I'm signing on to his new case.
Oh, we picked up a new case.
We did, Judge.
Mr. Palacio, you're now charged with the new case. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes. On February 5th, 2025, the officer was dispatched to a stranded vehicle at the 700 block of North Sam Houston Parkway. and the officer observed a car parked on the shoulder and a driver asleep at the wheel with the engine running and the car in park. The officer knocked on the window to wake up the driver, who woke up and refused to comply with the officer's command and drove the car 6 feet forward. The officer then requested the defendant exit the vehicle. The defendant put the vehicle in park, then drive multiple times before finally exiting the vehicle. The defendant was detained upon exiting the vehicle, and the officer relocated to a gas station where the defendant was observed to be dazed and confused and did not realize he had been asleep at the wheel. The defendant was also unable to communicate where he had been or where he was going. The defendant was asked to perform standard field sobriety test, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 1 out of 4. The defendant was read the DIC and declined to provide a sample. A blood search warrant was signed and executed.
I'm going to find that there's probable cause to go forward with the case. Can you look to see if he has any prior DWIs, and does he have a valid Texas driver license?
He does have a valid driver's license, Judge, and we
Oh.
did file for the ALR hearing.
And then I see he has a dismissed DWI out of Fort Bend, but no other DWIs.
There's no probable cause in that case.
I'm now ordering you, well, the first thing I'm going to do is I ordered you on your first case not to consume alcohol or illegal drugs. You've now picked up a DWI. Guess what happens now? I'm revoking your bond.
Judge, I would like to address that. So he does realize that this is a problem at this point, and he has enrolled himself in IOP and does have a meeting this afternoon to do intake for IOP, and I do have that email.
I can't show him preferential treatment. It's on any case here. I ordered not to do something. He did it, picked up a new case. You're staying with me. And I'm going to tell you now, if I find that you consume alcohol again, I will put you in a rehab facility myself in the jail. And if you respond well to treatment, it's a minimum of 9 months. Do you understand?
Yes, sir.
I'm now placing a restriction that you're not to drive any vehicle that doesn't have a guardian interlock on it. You're not to consume alcohol, illegal drugs, and Casey, I'm now going to probably give him a curfew. In the BMV, was he out in the middle of the night? Alex?
This is Your Honor.
I think it was after a bar closed. He was just sleeping in the owner's vehicle.
There's one consistent problem, and there's one thing that centers around every single problem that you have. What is that one problem? Right. You and alcohol do not mix. And I don't know what we need to do to get you to realize that, but I don't know. I hope that this is it. If it's not, it's going to be rather lengthy. Maybe that's it. Is it prison? I don't know. But all of the issues center around one thing. And I hope that you now realize this and do what you need to do. Because if you can't take care of it yourself, I will do it for you. And I promise you're not going to like the way that I do it. You were on bond for a theft case, and now you picked up another theft case. You now stand charged yet again with another theft. You're facing another 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 7th, 2025, the complainant observed the defendant trying on sunglasses in their store in the Galleria Mall. And after the defendant left the store, the complainant noticed the sunglasses were missing. The complainant then reviewed surveillance in which he was able to see the defendant putting the sunglasses in his front right pocket and leaving the store passing all points of sale. The complainant then flagged down an officer who was able to locate and detain the defendant. The defendant was wearing the sunglasses on his face and admitted to concealing them. The sunglasses were valued at $350.
Mr. Taylor, I'm going to find that there's probable cause to go forward with your case. I am now revoking your bond on the first case. Goes with you. Unacceptable. We will not continue to give you PR bonds. This is your third one. No more. I will appoint you a lawyer today, but you're staying with me. No going to the Galleria at all. Was the prior theft at the Galleria as well?
It was at a CVS, Your Honor.
Okay. No going to any CVS's, and I don't want you at the Houston Galleria. Do you understand? If I find that I don't know if you're going to get out. You get out, you pick up a third case, I'm gonna go absolutely nuts on the bond. Do you understand? Goes with you. Ms. Jewett,
Yes.
is Mr. Craig here? Deputy Miranda, I need your help. I don't know what more of no tolerance you don't get. Your device has been dead.
So Judge, I don't think it's been, it was low and then it went dead for, I think, a couple of days, but he didn't receive. Well, I understand that, Judge, but he didn't receive, I guess the device supposed to send something.
You know when you're supposed to charge the device. You know.
I think it gives you a notice or something that is dying out. And so it didn't give him notice. So he went to pretrial service to have him check it out to find out what was going on with it. But he's been on bond for a very long period of time with no issues whatsoever.
That doesn't give you the justification to do what you're doing.
Judge, I will say that I've contacted the device people over at 49, whenever he reported yesterday. They stated that
He only reported yesterday.
yes, we observed.
Unacceptable. Unacceptable.
Well, no, Judge, he reported because I told him that the device, that this was filed. That's the only reason why he reported over there.
The only reason he cared enough to go was because you told him he had to come to court. Otherwise, it would still be dead. It would still be non-functional.
I don't think that's the case, Judge, because it's been functional the entire time that he's had the device. So this is not he's been out for 2 months and the device has not been functioning. That's not it. This was just filed 2 days ago.
Because I wanted to take care of it now. And the reason is that he's on probation for a violation of protective order, picks up an assault of a pregnant person, and then picks up another assault of the same person. And he has another assault dismissed, and they're all the same person. And I told you that there was no tolerance in these cases. And I have here that you have a dead battery since 2/10 of, how long was the battery dead?
According to the viewer, I believe it started on the 10th, and then whenever he reported for.
Yes, Judge, that's what I'm saying.
Reported for inspection, we found no issues with the device itself or the charger.
I'm revoking your bond. You go to jail. I'm sorry. Bond conditions, bond conditions. There's no justification, right? 3 open cases. I've repeatedly told you, no tolerance, and you're just doing whatever you want to do. You're not charging it. Goes dead. So does the bond.
Judge, it went dead on the 10th, and he immediately went in to go have it checked out because he
No, he
didn't know.
didn't. No, he didn't. 2 days later, because you said you got to come to court, it's probably a good idea for you to go get it checked out.
That's not how it happened, Judge.
Tell me.
When I got the email, I said, hey, there's an issue possibly with your device. He said, I got no notification whatsoever that it was dead. So I will go down there and check it out to see what's going on. I didn't tell him about a court date because I didn't know about the court date at the time. I got the motion first. Then your letter came after the fact. So he went on his own to have it checked out. So if you look at the records, I mean, he's been out for a while and this just happened. 2 days, that's it, Judge.
They tell you that you're supposed to charge this thing on a daily basis. They tell you that you need to put it by the charger every day for a specific amount of time. And if you don't, the battery goes dead. So you know what you're supposed to do.
I understand that, Judge, but also if the court remembers that he is also keeping a newborn baby, so maybe he put it in.
That's
He was tired. I mean, I don't know.
it's been dead for 2 days.
It's only been there for 1 day, I believe, Judge, because he went on the 11th, I believe. Today's the 14th.
No, she said yesterday he went. Today's the 14th. That's the
Today's
13th.
14th, I'm sorry, that was the 12th. I don't know why I thought it was the 13th.
So when did he go?
The 12th.
No, the battery goes dead on the 12th. When did he go to pretrial?
He went to pretrial on the 12th, Judge. His battery went dead on the 10th.
Oh, I'm sorry. Okay, battery goes dead on the 10th. Goes to pretrial on the 12th. So he's without a device 2 days. I'm sorry. Goes with you. Morning, Mr. Benjamin. You are charged with driving while your license is suspended. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
It's Judge. On February 3rd, 2025, at 11:40 a.m., the officer ran a license plate search on a vehicle and found the vehicle to have expired registration. A traffic stop was then initiated. The officer notified the defendant for the reason of the stop and asked for the defendant's driver's license. The defendant provided a Texas ID that did not belong to him, and the officer asked for a name and date of birth. A search of the information provided showed the defendant's driver's license to be ineligible, and the vehicle also did not have valid insurance. The officer did a person search on the defendant and found the defendant had a bond condition for an ignition interlock device, and that the vehicle did not have the interlock. The vehicle is registered to the defendant.
Johnson?
Let's go through your stuff. And I'm just from 2009. DWI, possession of a controlled substance, robbery, theft, possession of a controlled substance, felony theft, felony theft. Here's my concern. 2018, DWI second. 2019, DWI second. 2019, possession of a controlled substance. Further in the year, DWI second. Possession of a controlled substance, and now another DWI, and now driving on a suspended license. I don't know if you watch the news. Every single day, someone dies from an alcohol-related collision in our county. Every single day. Watch the news. It's really, really unfortunate when a button on a phone and $30 on an Uber will get you to anywhere you want to go in this damn county. Don't matter where you want to go. It's a geographical oddity. It's so easy to just hit one button. I don't know what we need to get through to you, Mr. Benjamin, but I don't know if you're going to bond out. You will be signing an affidavit with me today, promising me you're not going to drive. And I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing. Every single time you get behind the wheel, you can be facing 6 months in jail and up to 6 months in jail and or a $500 fine. Do you understand? Do not drive. It's really scary what happens every single day in our county, and it's so tragic. Don't drive. This is the promise that you're going to make to me. All I'm begging you to do is don't kill someone. Please, don't kill someone.
There's a lot of randomness in it, Judge.
The only thing my concern is who broke the window? Did he break the window?
And Your Honor, so according to the DMs, what the complainant said is that she saw him walking away. She heard the broken window. She came downstairs and saw him walking away. And then that's what we have in the DMs. And then I spoke with her yesterday as well. She repeated the same thing, that he was the only one there when the window was broken. And that's what she said. She saw him outside the window door when it was broken.
He's walking away. He actually calls the police because he's being harassed by this woman because she's saying that he broke a window. And I don't think there's any list of physical evidence like glass on him or anything, or in the whatever stuffed animal.
At what point did the cops come and did they arrest him on the spot? What, do we have any other physical evidence? Do they?
We have The two further was complainant said that he was approximately 20 feet away from the back door when she saw him and that the officer found the window to be shattered. And then the complainant showed the back door to her apartment.
I mean, how do we know he did it?
No one's saying that he did.
I mean, no one saw, it's.
To be honest, just what we have is that the window was broken and then she saw him outside at the time when she came downstairs to check on. That's what we have.
I get it. I
Yes,
get
Judge.
it. I don't think it's enough. However, the fact is, we're still having issues with the same complaining witness. I now have to take more drastic action to ensure nothing happens in the future. So now what I'm going to do is I'm putting an ankle monitor on it and I'm barring him from going within 500 feet of where she lives or where she works.
Yes, Judge. Ankle monitor, just want to make sure it's ELM and not scram.
Correct.
Acid fees be waived. Okay. I'll add.
How far do they
Judge-
live from each other, Alex? You know?
Do you have the same complex?
It was described as across the street. But when I spoke to the complainant, she said that they do not live across the street, that he was staying at a friend's house. But he told officers that she lives across the street.
So what I'm doing, Mr. Franklin, is I'm going to put a monitor on your ankle and there is a radius of where you cannot go where this person lives or works. And I mean, we may have issues with bond conditions as it is, because if I ordered him not to have weapons on the terroristic threat and they show me that, or they prove to me that you have weapons, I'm going to put your butt in jail. So maybe we should have a formal bond hearing to see if in fact you can prove that he has a weapon.
So I have some hesitancy about everything, Judge, mostly because my client's orange sheet is quite extensive. So the jail has diagnosed multiple mental illnesses. I'm trying to track down his competency because I was appointed, I think, December. So there's been prior competency motions. I'm trying to get the reports from them, which is difficult because I forget what agency does the mental health evaluations. They're saying that they don't exist. So I'm trying to find his mental health records, Judge. It sounds to me like it's bipolar schizophrenia or schizoaffective. And so I think that my client is likely going to have severe mental health issues, which have been causing issues. And I think that's going to be the heart of all this. And so I'm trying to push for treatment. The case is just brand new is the problem.
You were ordered not to be in possession of any weapons. And they're telling me now that you have a new case and that you have an alleged knife as well. I want to set this for a formal hearing on Monday. And if they show me that you have a weapon in violation of your bond conditions, I'm going to bring it. Do you understand? You are not to be in possession of any weapons whatsoever. Get a hold of your witnesses, get a hold of the cop. Let's have a formal hearing on Monday to show me whether he's in possession of a weapon or not.
Yes, Judge.
Yes, Judge.
In the meantime, like I said, if I find that you become a danger to my community, it's really not going to go well for you. Do you understand, Mr. Franklin? There is no excuse. You will get this ankle monitor today, and you're not to go within 500 feet of where this complaining witness lives or works. Good morning, Mr. Murdoch. Sir, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On February 16th, officers observed a blue Kia Forte at 6300 Antoine Drive. The officers observed the vehicle make a U-turn where there's a prohibited U-turn sign. A traffic stop was initiated. Officers had previously observed this vehicle pulling out of a known after hours bar located at 6314 Antoine Drive, Harris County, Texas. The defendant was a driver. Officers observed bloodshot eyes and a strong odor of alcoholic beverage. The defendant admitted to drinking 2 Bud Lights. Standard field sobriety tests were performed, 6 out of 6 HGN, 1 out of 4 one-leg stand, and 4 out of 8 walking turn. The officer observed a 12-ounce Bud Light bottle of beer that was open and about 3/4 full upon an injury.
Drinking in the car while driving.
There were also two unopened shooters appeals in legal counsel. The defendant consented to arrest. TAC came back as .112 and .109.
I missed the basis for the stop. Can you tell me that one more time?
They saw the vehicle perform a U-turn in an area where the U-turn was prohibited.
Okay. Mr. Murdoch, I'm going to find that there's probable cause to go forward with your case. I would figure that it was damn elementary that you're not to have alcohol in the car while you're driving. I am now taking away your privilege to drive. You were not allowed to drive. You will be signing an affidavit with me today promising me you're not going to drive. And I don't give a rat's behind what your excuse is if there's a burning building and you have to say 50 children. Do you understand? Every time you drive, it's punishable by up to 6 months in jail and a $500 fine. Every time you drive. Mr. D,
Yes, sir. Now approach your honor.
please.
Your Honor, I am here on Mr. Enrique Rodriguez. I received email from pretrial services stating that my client, Mr. Enrique Rodriguez, failed to go and to pretrial service and pick up the portable device.
Is Mr. Rodriguez here now?
Yes, sir. He's here, Judge. Mr. Rodriguez, come forward, please. I think he was supposed to get it by 1:13:25.
You don't have the devices we ordered you to do?
No, sir. I have a letter from the State Department of Transportation in Austin saying I am
No.
not allowed to drive a car, so I figured I didn't have to get it. So I can't drive. I didn't know. After I said I can't drive, why should I get it? And then
Because I ordered you to get it. And now I'm revoking your bond and I'm putting you in jail because you've been a whole month without having it. You decide on your own? Courts don't work like that. It goes with you.
Thank you, Judge.
You are facing up to a year in jail and or a $4,000 fine on your new terroristic threat of a family or a household member. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge. On February 18th, 2025, in Harris County, Texas, the officer was dispatched to a family disturbance. The officer met with the complainant who stated that the defendant had been threatening her. The complainant stated that she and the defendant had been arguing all day and that the defendant stated he would stab her and throw her down the stairs. The defendant stated he would shoot her, and then the defendant showed the complainant a large hunting knife, and that's when the complainant advised that she feared for her life.
Who is the complaining witness in this case? Same as in his open assault?
No, Your Honor, they're a different complainant.
Mr. White, I'm going to find that there's probable cause to go forward with your case on the new terroristic threat. I asked you one thing, sir. I asked you not to become a danger to my community and not to pick up a new case. You now have. I will now revoke your bond in the assault case. It goes with you. $5,001 for the assault, please. I am now issuing another protective order on this person. You know, is there a protective order that's open in the first assault? No? Because if so, we could be looking at a violation of protective. I'm issuing a protective order that identifies Farah as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Mr. White, let me be clear with you now. I will do everything in my power to protect my community at all costs. You pick up a third case, I'm going to go absolutely bonkers. Do you understand?
Yes, sir.
You are not to smoke, use any kind of illegal substances, consume alcohol. I'm going to test you, and I'm going to put a GPS monitor on your ankle prior to release, please, so I know where you are at all times, and I don't want you anywhere near any of these complaining witnesses at any time. Do you understand? Okay, but the problem is that we continue to have issues with Mr. Franklin.
So Mr. Franklin is going to have issues on bond or not, Your Honor. His mental illness is quite severe. He's received hospitalizations in the past. His orange sheet is right at a page, if not over. And so the system is aware. I would take this court or ask this court to take caution in the sense that we're not having a formal hearing. There's no testimony presented. I'm fine with having a conversation. But if the court should wish to revoke
We're
his bond.
having a hearing right now.
Well, then nothing has been admitted because there was no admissible evidence. I'll find to discuss with the court what has been alleged, but there is no admissible evidence of either location or possession because nobody has testified to either. And I don't think the pretrial services officer in this room would have the ability to testify how a GPS device works. Not to be mean to her, but it's not her job. And so she's not going to have any knowledge of the firsthand knowledge of the device.
We continue to have issues with Mr. Franklin, and I'm tired of it. I'm not dealing with this anymore. I only have one way to fix this.
So I've spoken with the state, particularly the chief. We're leaning towards reaching a resolution on a mental health diversion, Judge. It's not 100% that we're there, but it sounds like we're going to do it where we send him for an evaluation. So I'm going to file a competency evaluation just in case. But
so that there's another 30 days. I'm not going to sit here and wait for him to have another bond violation. No, because he's doing whatever he wants to do, because that's what's happening here.
yes, Judge. And if you'd like to revoke his bond, which I can understand the court's position, I would just ask that we have a formal hearing with testimony where the rules of evidence would apply, which statutorily they would apply to any revocation of bond.
I'm still going to take him into custody. I find that he's a danger to our community. He's continuing to just. Mr. Franklin, what am I supposed to do? Continue to let this happen?
For me,
Don't form.
I ain't getting no justice.
I found no PC on your case last time.
I ain't getting nothing to nobody.
All right, Judge, and just to distinguish where we're at, this was not an alcohol event at all. He's been.
I don't know that. How do I know that?
It reads.
I know that, but what in these instances, what happens is someone puts something in between the leg and in between the device to be able to subvert any kind of reading. That's what happens. So when you see something where there's no contact with the skin for a certain period of time, here it's 2 days, there's no contact.
And that's exactly why we're here, Judge. And I showed the prosecutor his leg, and we've been having issues with his whole entire leg is completely chewed up because of this device. It is.
But the solution is you come to court, you say, hey, I need to switch it to another leg. You don't just on your own initiative start sticking a piece of paper or a towel or something in there,
Judge, I get it. I mean, just there's a tamper event doesn't mean it was intentionally done. And he's on GPS and
There's no way for us to know. All I know is that it broke contact with the skin for 2 days.
I agree.
Come up. I appreciate your tenacity, Mr. Leeper, but he has a DWI. He's got an FSRA where we have a dead body. He's not one violation. We're now working on our second to third violation, and now you're putting something, or I don't even know, but all I know is that the device lost contact with your leg for 2 days. That is unacceptable. When you have issues with a monitor, you bring it to your lawyer's attention, you come to court and you say, look, this is what's happening. You don't put something in there in hopes that we're not going to notice. And now you tell your lawyer after the fact. I'm sorry, Mr. Lee, but what choice do I have but to revoke his bond again? I know that it's upsetting, but no, I have a very serious case with you. You've been ordered not, you know that there is no tolerance in this case. Yet, you lost contact for 2 days. I'm revoking your bond. Go to jail. Sorry.
What's his bond?
Mr. Leeper, I don't know. Judge, I'm not getting through.
Well, this is the other side of it too. He can't switch legs. He's got a GPS on his other one. He should have I agree with you, this court, I agree with it, but something's good. We're gonna have to change something or even move him to like a full-time portable blow Because it's not an alcohol issue, Judge. And, he obviously made the mistake,
I
but
don't know that, right? Until you come here and tell me, I don't know. The only thing I know is we have a DWI, we've got an FSRA, we've got a dead body, and I've got multiple violations. And now you're hiding, you're doing something 2 days that I don't know about? You know what the proper procedure is when there's an issue. And you're just not doing it. You do what you want to do. That's not the way it works. And now you go to jail. Goes with you. I'm sorry, Mr. Leeper. I can't continue to justify it.